In part 2 of my podcast episode with Phillip Coburn, we're going to talk about the common mistakes that landlords make in order to claim possession of their property back. We'll also talk about deposit disputes as well and how that affects a possession claim and how that can reward tenants if not done correctly. We'll also talk about some of the legal mistakes that landlords make before they even get to courts. And we're going to discuss the current court delays as they are, because with the Renters' Rights Bill on the horizon, looking at it, there'll be even further delays than what there is currently. So we'll discuss how the courts can sort that out and what needs to be done in order to ensure that there are no further delays and that it minimises the time to get possession of your property back. So absolute golden value in this for you if you are a landlord. So make sure that you're listening and make sure that you subscribe to the Investors Corner podcast. So going on to legal mistakes then that you see landlords make. So you've obviously dealt with a lot of landlords, a lot of cases. I have in my 16 years of being in the lettings industry and going to court and dealing with solicitors. We recently sent out a compliance test to landlords. This was more landlords doing it themselves. Yep. We probably had about 150 responses to where landlords have filled in this quiz and sort of testing their knowledge on stuff. It was a mix of landlords that have got 10 or more properties, landlords that have got 1 to 5 properties. Yeah. Probably around 60% of the responses that came back scored less than 70%. Gosh, and these are landlords trying to do everything themselves. Yeah. And some of the answers to some of the questions were just sort of astonished me that you've got people out there that are trying to do it themselves that didn't know the gas safety regulations was a thing. Yep. Didn't know that EPCs had to meet a required rating. Didn't have any communication platform in place to communicate with their tenants. Never done property inspections. And I was bewildered how these people continue to do it and be landlords, not knowing their responsibilities as a landlord. So what are some of the common mistakes that you see from landlords making?
Yeah, I mean, there's a lot, and it's not really an unfair criticism, or not trying to be, but that's why you have agents and lawyers to check those things. I mean, it's very common that I'll get instructions. Not only off landlords, to be fair, as off agents as well. I'll get instructions and something's not right. And it doesn't mean, the world's going to fall apart or we can't fix it. Most things can be cured, and that's why we check them first. But the most common things can be as basic as the tenancy agreement. So, I can look at a tenancy and it might say the tenant is Mr. P. Coburn. Well, my name's Philip. What happens if my son's an adult and his name's Paul? Who's the tenant? Mr. P. Coburn. So if I decide, to leave my, I haven't got a son called Paul, by the way. Leave, poor Paul in the property. Well, is he the tenant? Because the tenancy says P. Coburn, so it's not very clear, is it? Right. And you then start looking at, well, where's the rent coming from? Oh, and the landlord may then say, oh, well, actually, there was. I didn't really think about it, but 6 months ago we started getting it from a different account. So literally filling the tenancy, putting the date of the tenancy starts, putting the amount of rent and when it's due, the address. Again, dealing with blocks of flats can be a nightmare. At various cases I'll have a tenancy which says flat 3. I'll have an EPC which says top floor flat. I'll have a gas certificate which says 3rd floor flat. And they're probably all the same thing, but I don't know that because it's not my building. No. So it's just, again, consistency. And that might not be the landlord's fault, that or gas engineer has written it's the top floor flat or whatever it may be. So it's things like that. Doing it themselves, which you mentioned. So if a landlord tries to do a Section 21 or Section 8 notice themselves, Section 21 in particular, and I know it's going, but it's a real minefield. The form itself's really simple to fill in. You can still get it wrong, obviously, but it's quite simple to fill in. The work comes in knowing you can serve it in the first place. And you mentioned the gas regs, and I have cases where there's deposits, they're not protected, prescribed information's not given. Gas regs in particular, there was a case last year where a gas certificate didn't have the landlord's or agent's full name and address on, and the case was dismissed. It was a county court case, which means it's not binding on other county courts, but it's quite a persuasive decision. So again, if I'm getting cases now and I'm looking at gas certificates, if it says, avocado property but not your address, well, the certificate's defective according to the gas regs, because when you look at them, there is a chain, and one of those points says it contains the landlord's or agent's name and address. So if it doesn't comply, and then the knock-on effect is Section 21's wrong. So the prescribed requirements is a very common problem, but I wouldn't, although I'd expect landlords to be aware of these things, like I've got to get one, I've got to get a gas certificate, I wouldn't necessarily expect them to know their engineer hasn't filled it in properly, or then put the gas registration number on or something like that. So it's, usually from a strictly landlord point of view, it's probably not filling things in properly. Another common one is, a landlord might own a property in a company name, but they might have put their personal name down as the landlord. That might be okay because the landlord doesn't have to be the person or entity who owns a property, but it might have been a genuine mistake, and they don't realise they've just opened themselves up to some personal liability. What happens if the tenant's claiming disrepair and sues for damages? What happens if you go to court, you get it wrong and you're struck out and you've got to pay the other party's costs? By putting your personal name down, you've opened yourself up to personal liability. So it's just thinking about those things. And sometimes it's fine if there's a different name, there's an explanation for it, and there's no problem at all. But it's quite common, really, that someone hasn't thought about it. And then that can all have a knock-on effect to court proceedings. So having done their own notice, their own tenancy, their own notice, they then have a go at doing their own proceedings. And, a common error might be not having the right notice with the right set of proceedings. So someone might do a Section 21 notice, but then issue a rent possession claim, and not really thinking about what these questions don't make sense. Or they might do a Section 8 notice on rent and fill in a accelerated possession claim form, which is usually for Section 21 notices. The kind of the consequences of that are time and money. So if I will, plenty of times I've spoken to clients in the past where they come in and it might have been from their agent, not necessarily the landlord, but I'll get the notice. It's a Section 21 notice. We've had 2 months go by and I have to say, this is wrong, and for one reason or various reasons, but we're going to have to start again, particularly at the moment where these aren't going to exist, Section 21 notices, for much longer. So do you want to risk issuing a claim today? It's dismissed in 6 months' time or 3 months' time, and by then the law's changed and you can't do a new one. Or do you want to just suck it up, do a new one? You've wasted 2 months, and start again. And it can be a difficult conversation for to have with an agent, a landlord, but usually it's not always a glaring mistake. It might be the common ones about how to rent documents, actually, that I'm not sure how you guys do, but the requirement is that a hard copy is given unless the tenant agrees in advance to have an electronic version. Lots of agents, they use DocuSign, and it electronically sends the how to rent guide. Well, if prior to that point, if there's nothing from the tenant which says, I will take that electronically, well, you haven't complied with the rules because they haven't had a hard copy and they haven't permitted you. So I'll usually say to agents, have something in your tenancy application which says, I will accept receipt of things electronically, and in the tenancy itself, have the email address, and in the section 20 pages in or whatever it is that says service of notices, that one of those can be serviced by email. It's easy to cure as it happens, because all you do, and this is routine, prior to serving a Section 21 notice, doesn't matter what I've been told by a client, I will resend everything to the tenant anyway.
Which is exactly what we do when we serve the Section 21 notice.
And then that solves all, as long as you've got the right documents.
Yeah.
That then solves all of the problems. And even when the tenant comes and says, I didn't receive documents A, B, and C, I'd like to think the judge is going to believe me that I've sent them, and I can provide some evidence of it. So that's quite a lot of common problems, unfortunately.
And that's the thing, when you get landlords trying to do it themselves because they feel like paying an agent is not beneficial to them.
Yeah.
Or they think that agent's charging too much for doing nothing. What they don't understand is that this is all of the stuff that we do as an agent. We make sure that the compliance levels have been satisfied. We make sure that the documents have been served to the tenant. We make sure that everything, or the tenancy agreement, has been set up with correctly, with the correct information on there. So from our point of view, we're making sure that the responsibility is taken away from them, which in turn avoids them having a financial penalty or anything further on down the line. So that's where the value comes from.
Definitely. And I have a kind of common phrase I say to a lot of people, like spend money to save money.
Yeah.
It's I appreciate solicitors aren't cheap, but if you want someone to do it cheap, there's plenty of people who do it online, as a landlord service. I had a case recently. It didn't proceed in the end, but again, client had used a landlord service online to do a notice, and it was wrong. And again, that's not the landlord's fault. Is they've paid for a service, they've done it.
Yeah,
but it was wrong. I'm probably overcautious, but there's a reason, because I go and do the court hearings.
Yeah.
I see cases get dismissed to see unhappy landlords, and then who are ordered to pay out a lot of money to another tenant solicitor. Yeah.
It's better to be cautious than not, or overly cautious, should I say, especially with something like this, because any little thing, from what I've seen in the past years and from how things have gone in certain cases that I've been to, if there's one little thing that the judge can find that will favour a tenant,
they will.
Then they will.
Well, yeah.
So
it is, and as a lawyer, I'm experienced enough to kind of know what potential problems might be, but also experienced enough to challenge judges, because it's probably a misconception that just because you're before a judge, they know the law.
Yeah.
And it's not always the case, and it's not criticism of judges, but if someone is like I've done housing law and civil litigation and all sorts of law over a long time. If I go and sit as a judge tomorrow and I'm doing a divorce, I won't have a clue.
No.
So I'm relying upon what training I've been given and looking things up, which I'll do, obviously. But if there's an experienced practitioner in front of me telling me the law, I'm going to listen to them. But there's a way of saying it, nicely to a judge that you think that might be an error, but because again, this goes back to the point of having someone look at these things in the first place. That if you get a set of papers and a reasonably competent solicitor is going to pick holes in it for a tenant, well, you can only say that, and the landlord can walk into it with their eyes open, and have that worry in the back of their mind, or are they going to do it? But judges can do these things anyway. So even if you think, that tenant's not going to reply because, I know they've got these issues or those issues, a judge has still got to look at the paperwork and decide if you can have your possession order, and can decide you can't.
Yeah.
So it's not, you can't just assume you're going to walk through open doors all the way through a case. So it goes back to having a professional, an agent, lawyer doing it.
No, so back to that power team that I was talking about earlier, surrounded by people that know their certain industry, that's had the experience of dealing with it. And if you've got those people, then you're in safe hands, you're in the best place.
Yeah, you don't get an electrician to do a plumber's job, for example.
No, so exactly. So court backlogs then at the moment. Big thing that's sort of being talked about is that how busy the courts are how much of a delay there currently is with current legal cases. Now, obviously, with the changes coming into effect, we haven't really heard anything on how the courts are going to be improved.
Yeah.
What sort of timelines we're looking at from those courts. A lot of people are trying to get everything delayed because of that certain court system that's in place at the moment, because they feel that there's going to be more legal cases.
Yeah.
There's going to be more things that are delayed. There's going to be more stress put on landlords as well. So how do you see that playing out? You know, is it going to improve? What's the timelines that you're experiencing at the moment to get possession back?
I mean, it has to improve is the answer. But going back to I mentioned it before about the renters reform. So under the Conservatives, the position at that point was, we want to bring about these changes. We need to bring about these changes, but before we do, the court system needs an upgrade.
Yeah.
Until there's that upgrade, it can't come in. And, that was 2019, I think it was. Then we had COVID, and then it just never changed anyway. So the Renters' Rights Bill and the Labour government, they must be aware of the problems with the court system, but I think they've wanted to carry on anyway and say, well, it's going ahead anyway. So in terms of what can happen, well, partly now you can do electronic issuing online. So if you've got a rent arrears case and you've done a Section 8 notice, it's grounds 8, 10, 11, for example. After 2 weeks, I can go online on possession claims online. I can issue the claim there and then. It's issued immediately. And then 9 times out of 10, you'll get a hearing date within a few minutes. If not, maybe a few days. And it's usually around 6 to 8 weeks later, regardless as to where the court is. You'll then have the hearing, and if you get what you want, you might get a possession order from anything between today and 6 weeks. The problem currently then comes with evictions. So if the tenant leaves, great. If they don't leave, and the landlord wants vacant possession, then they need to apply for a bailiff, and that's very much dependent on area and court. So, where I'm from in Merseyside, it's usually about 6 weeks, maybe 8 weeks for an eviction date. It's from when you apply. If you go to central London, it could be 6 months, and there's nothing you can do about it. The civil procedure rules just provide that a tenant needs to be given at least 2 weeks' notice of the eviction date. So we've already got that backlog, but that's not so much the issuing and the hearing date. That's the bailiff backlog.
Yeah.
The way I can look at it in terms of backlogs is what happened during COVID. So, I remember going to court the day COVID hit, if I can put it that way, when, we were told to stay at home.
Yeah.
I went to court. There was nobody there. I was told by the usher that all hearings had been vacated until further notice. And that was that. And then nothing then took effect for several months. And when it did then kick back in, courts probably took maybe 6 months to clear backlogs. And that's probably a good way of looking at it, because there were backlogs, because people were still sending things to court to issue claims.
Yeah.
And the courts were just sitting on them because they couldn't do anything. So they did have big backlogs. But rather than... common sense would say, well, let's open more courts. Let's have more court staff. It's been the opposite. Prior to that, kind of satellite courts, like in smaller towns and areas, have been closed. Staff being cut.
Yeah.
There should be more automated processing. So I don't know what the government's plan is to deal with all of these. I should say there might not be a lot of new claims. Everyone's just assuming... Well, because of the change, everyone's going to do a Section 21 notice and get their property back. Well, people may want to keep their property, get their rent, and just see what the changes are. But if there are lots of changes and there are lots of court proceedings, currently it's going to be court dependent on how busy it is. So if you go to Manchester County Court, for example, if you send something in on paper, you might not see it back for months. And it can, if it's an accelerated possession claim based on Section 21, if it's sometimes you have to do in court proceedings applications. It could be for a number of things, but if you send in an application for whatever it may be, again, you could be waiting months for a hearing date, and it's the same in a lot of courts because there's not sufficient judicial resources to deal with it.
Yeah.
You might have, say there's a place in the middle of nowhere, right, and there is a court, but the court's 30 miles away because that's the nearest court, and it deals with countless areas around there, and there's 2 judges. Well, you're stuck, aren't you?
Yeah.
Because you're going to be waiting because there will be more things that come in first that are more urgent. So the ideal situation would be to dealt with electronically. There's no reason why a Section 20... I know Section 21's going, but currently Section 21 case couldn't be dealt with electronically. It's a kind of a cumbersome exercise, filling in a 15, 20-page form, attaching hundreds of pages of documents, and then sticking maybe 3 or 4 copies of that in the post or for court, when you should just be able to send those electronically. Courts don't accept more than 50 pages on an email. So if you want to issue, you're a bit stuck in terms of what you can do. So there needs to be an electronic system for issuing other claims, not just rent claims. There's no reason, as I said, why that can't be done. And there needs to probably be shorter listing of hearing times when things are a bit more urgent. So there's a mechanism at the moment for antisocial behaviour where if someone, doesn't have to be a tenant, could be a visitor to the property, has threatened a landlord or an agent or a contractor or anything like that, you can give a notice. You can use ground 14, which means you can issue straight away after the notice is served. The rules do allow for not waiting 6-8 weeks for a hearing. You can have a hearing sooner, and you can try to do away with that notice period about the eviction that I mentioned before, the minimum 2 weeks. So, but that only applies to the most serious of cases where maybe it should, but that's what it says. But if you have someone who owes you £10,000 in rent, that indebtedness is going to increase over 6 months in some courts, and that's worse for the tenant and worse for the landlord, isn't it?
Yeah.
So there isn't a system currently that I'm aware of where the government has said to the courts, and it's not the court service's fault, by the way, but the government need to say, this is how we're going to revolutionise the court system.
Yeah.
And all that anyone was ever told under the previous government was it needs to be updated and revolutionised.
Thanks for listening to part 2 of my podcast episode with Phillip Coburn. I hope that you found it useful, and I hope that you've picked up some golden nuggets within that episode to use for the future, and to maybe get you thinking that if handling the property yourself is the correct thing to do. So look out for part 3 released shortly, where we'll be talking about how to monitor your tenancy going forward, what advice to have going forward, and how to protect your investment so you don't make the mistakes that are being made currently that delay possession of getting your property back. So make sure that you're listening to that one, and make sure that you subscribe to the Investors Corner podcast.